You're listening to an Airwave Media Podcast.
And hardly less marvelous.
There on the screen before me was the president's tense face, speaking the firm, crisp sentences that burned into my consciousness like the voice of doom. Seizure it was, with the same finality as a death sentence. I felt physically ill. That's Clarence Randall in 1952. He's the head of Inland Steel, one of many steel companies that President Truman decided to take property from. It seemed to me that all I had learned of government from school days on, all that I had believed in with respect to the balance of powers in a republic, all the safeguards conceived by the founding fathers for the preservation of our democracy, had suddenly been swept away. The president made it clear that this was the end of the matter. There'd be no further talk. One man, he said, had coldly announced that his will was supreme, as Caesar had done, as Mussolini had done, as Hitler had done. Got to get the H word in. So does the New York Daily News. Titles its editorial in 1952, Truman does a Hitler. What had happened? Well, we are in the midst of the Korean War still in 1952. And there is a threatened steel strike. And one of the big plants that this is going to affect is Youngstown Sheet and Tube, which is interesting, right? I mentioned that same plant in my episode about the closing of manufacturing plants, but here it is showing up in an episode about presidential power. Same place, different issues in history, right? But this time, it is a booming plant. There's no closure going to be imagined. That's still 30 years away. Workers and steel plant management cannot see eye to eye. Here's the issue. A law had been passed in the 1946, should say 1947. A Republican Congress had passed what's seen as a fairly pro-business act, Taft-Hartley. Robert Taft, the famous conservative from Ohio. And this gives the president powers to stop a strike. Truman rejects using it. First of all, he had bitterly opposed it. It was passed over his veto. He called the bill a slave labor bill. Here's what Truman says. It may be that Congress will feel that government should try to force the steel workers to continue to work for the steel companies for another long period without a contract. Taft-Hartley called for 80 days. Even though the steelworkers have already volunteered remained at work without a contract for 100 days in an effort to reach an orderly settlement of their differences with management. Was Truman, though, really a Mussolini in this situation? Well, certainly there's some public opinion at the time, contemporary public opinion that sees this. I doubt the steelworkers in the plant. They were quite happy with his announcement. And I think you got to keep in mind the context of this situation where Truman, by the 1940s, is coming off World War II. He's the president that effectively ends World War II. And during a wartime, the president has certain emergency power, certainly relating to the military. Here's what Truman says on April 9th, 1952, to Congress. The Congress is undoubtedly aware of recent events which have taken place in connection with the management labor dispute in the steel industry. These events culminated in the action which was taken last night to provide for temporary operation of the steel mills by the government. I took this action with the utmost reluctance. The idea of government operation of steel mills is thoroughly distasteful to me, and I want to see it ended as soon as possible. However, in the situation which confronted me yesterday, I felt that I could make no other choice. This is the Korean War, and the Korean War is not declared by Congress. It's referred to consistently by Truman as a police action. We do not yet have the War Powers Act. That's going to take place during the Nixon administration. So Truman's really going on his own authority, and the authority is the kind of the leader of the free world to prevent communism, to help out South Korea, and all of that. But you're already on a little bit of a flimsier ground. So when this goes to a Supreme Court that's been, at this point, relatively friendly to Roosevelt and Truman, they ruled that President Truman had overstepped his constitutional authority by seizing mills. The founders of this nation, writes Hugo Black, entrusted the lawmaking power to Congress alone in both good and bad times. Congress, this was key to this case, had already addressed labor disputes through Taft-Hartley, and Truman just simply ignores it. He may not seize private property to settle labor disputes. It is the duty of the courts to say where the constitutional boundaries lie. Justice Robert Jackson wants a more fuller explanation of where presidential authority might lie, and so he writes a concurrence. And this concurrence actually is used quite a bit in these areas. So, Jackson outlines 3 situations in which presidential power could be judged. Maximum power, when the president acts with expressed or implied authorization from Congress. That's when his authority is at a maximum. Still doesn't say you can do whatever you want, but it's at a maximum. Category 2, Congress has not spoken, and the president acts on his own independent powers. In the absence of either a congressional grant or denial of authority, he can only rely on his own independent powers. Category 3, the lowest ebb, when the president acts against the will of Congress. His power is at the weakest. When the president takes measures incompatible with the expressed or implied will of Congress, his power is at its lowest ebb. Robert Jackson, in his decision, is deeply concerned about the precedent of unchecked executive power. The Constitution diffuses power to better secure liberty. That a crisis should evoke the most energetic response of the executive is natural, but it's not a reason for us to abrogate the Constitution. You see, an executive's always coming at the courts in a way, saying, hey, I'm the one who has to deal with the day-to-day emergencies. And it is true that courts have a little bit more leisure, and that's always been the case throughout history. Courts have, and I hope will, continue to annoy executives at the federal and state level. With all its defects, Robert Jackson says, delays and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law. That's Youngstown Steel. It's a 6-3 decision. Truman has to give back steel plants that he has seized. So there's so much today about presidents and judges, obviously with Trump utilizing an expansion of executive powers, the only way to describe it, aggressive use of executive orders involving hundreds of thousands of federal workers, not seeming to really have much interest in seeking legislative approval for this. Now, one could assume, well, you can't really assume it, but one could suggest that the recent election and the re-election of a Republican House, narrow, and a pretty decisive election of a Republican Senate implies some agreement with Trump winning at the same time, applies some agreement with that program. But that's not how the Constitution works. That's not how laws work. I would argue that you'll never get the level of support in a legislative body, even one that really does support a president, then you'll get in an office in the White House, right? The resolution to do something by, say, an unelected group is always going to be stronger. A man is being pulled from his own home by officers clad in blue. Neighbors are upset. They line the street around the house. But the man is a gentleman about it. He knows that perhaps this isn't right. And around this, we have one of the key cases of presidential authority and how that relates to a judge's decision. And what a judge can tell a president to do. And in fact, this is a case where a judge is going to tell a president what to do. And a president is going to ignore it. But for other reasons, it might be a little different from situations occurring now, and certainly hasn't lasted in history as a big precedent. And we'll get into the comparison and the contrast, so important when we use history to look at politics, right? So often we just get the one, people just compare things. But anyway, let's talk about this fellow. His name is John Merryman. Who is he? People in Maryland like the guy. He was very popular with his friends. He was some kind of a leader, certainly. And he would have been an officer in what was called the Baltimore County Horse Guard, which is best way to describe it is a state militia. The time that he is pulled from his house is May 25th, 1861. And on that day, Merryman's arrested at his home in Coxeyville, Maryland. Union troops say they're acting under the orders of General William Keim. He has not read his charges. He has not given any indication he's about to appear in a civil court of any type. And in fact, he's taken and locked up in Fort McHenry. The general in charge of that fort, which is going to become very important here, and that's why I'm going to butcher his name, Cadwallader, does allow lawyers in. So by the next day, the 26th, he's already got lawyers. They confirm with the general they're not letting him go. They ask for Merryman to be released. You have no charges against him. The general says, no, I will not. And doesn't really, to the extent there's any explanation, it's awaiting orders from the President of the United States. They go to Roger B. Taney, who is the Chief Justice of the United States, but critically also because the court at this time is still doing circuit. So they're taking cases broken up in localities, and Maryland goes under Taney. Taney's from Maryland originally. He's from the Baltimore area. Be very familiar with some of the players involved, though he's been on the Supreme Court now since the time of Jackson. They get the right judge because Taney basically writes out, bring me the body of John Merryman. When they say body, they mean live body, okay? This is a habeas corpus case. And bring him before me. I'm the court. I'm the one that decides these things. Now, you could almost hear a pin drop in the court when an officer comes from Fort McHenry who is not the general, and they do not have John Merryman. The response says, we're acting under orders from President Lincoln, and he had delegated authority to the military to suspend habeas corpus. Taney's outraged, and he just simply writes on a piece of paper that the general is in contempt of court now, and they must produce Merryman again before him. He doesn't say the release. He doesn't say the Army has to release Merryman, which is a critical difference. But he does say, from what perhaps he could do, but he does say you have to bring him before me. The distances aren't large here. Taney's in D.C., and it's not that long a horse ride to Baltimore, Fort McHenry. Taney's order is not allowed to be served. In other words, the guards at the fort don't even allow the delivery of the message. And thus we're going to set up one of the largest kind of one-sided court cases that has to do with the executive authority. But let's get a little bit into what happened. why did they arrest Merriman? And it has to do with the time we're talking about. This is the end of May 1861. We have not fought Bull Run yet. The full Civil War has not been engaged, but states have seceded from the Union, and in some cases have taken over, say, federal forts, federal armories, and things like that. Maryland's right in the middle. And in fact, it's quite tense. And in areas such as, say, Baltimore, I think it would be accurate to say they're more sympathetic to the South. But they certainly do not want to see federal troops marching through their state, trampling on what they see as their rights. This comes to a head when Lincoln orders soldiers to come from the north to help protect the capital, protect his own safety, protect the safety of the capital as states are starting to secede and rebel. And unfortunately in Baltimore, the two trains are not connected, and you have to walk a bit to get from one train to the other. And Union troops are attacked by rioters during this time. Now, did Merriman start that whole riot? No, he's not singularly responsible. There's reasons why the Army's aware of Merriman, and we'll get into. But what he is a significant person in the Baltimore County Horse Guard, and then the Baltimore City Guards are also going to be an important factor here. So the state of Maryland, not quite being for the Union, not quite being against the Union, set up these state militia units. In fact, they're set up during the time of John Brown's Harper's Ferry incident to allegedly, protect the state and keep aware of the state's defenses and things like this. So as federal troops get active in the run-up to the Civil War, you're seeing things like tailing groups of federal troops. So Merriman's Horse Guards are going to be assigned to the Pennsylvania Union soldier regiments and see where they're going. And what they particularly want is them not going through Baltimore. They feel they have an agreement with someone anyway that the Army won't bring troops through Baltimore anymore because it's trampling on their rights and also they're just causing strife. In fact, Merriman goes as far as he's not just tailing these Union troops, he actually goes into their camp and talks to them. He even offers them, like, I have a cattle, I'll be happy to slaughter this cattle and provide a meal for you that you're here. But he wants them to go around Maryland. There's ways through Pennsylvania they can get troops. There's ways maybe going to Annapolis and then going by boat. And the Army hasn't quite decided all this yet. They do realize that Baltimore's a problem after the riot. But there's a little more that goes on. There's a meeting that occurs in front of the Washington Monument in Baltimore. Baltimore has a monument that's, I'm not going to say it's better than the Washington Monument in D.C., but it is earlier. It's the first one, and it's a very nice monument. So they have a meeting there, and Governor Hicks of Maryland is talking, and he says, the Union must be preserved. And if that speech was made in Massachusetts, if that speech was made in, most of Ohio, most of New Jersey, most of New York, there would be cheers and whistles and people repeating it, Union must be preserved and things like that. But in Baltimore, he gets booed and hissed at. And they're angry, and it shocks the governor to the point that he feels his safety is threatened. And he changes the speech up and says, but we're going to stand up and we're not going to allow federal troops to come through our state. And the crowd is a little more settled. He still has to ask the Baltimore mayor if he can stay with him that night. He doesn't even want to stay in a hotel. He feels like someone's going to shoot him. And so somewhere around this visit that he's having at the mayor's house, and the account of the governor is that he was kind of awoken at night. Merriman and some others asked for permission for a plan to let's make sure the troops can't come through Baltimore. And what we figured out is if you destroy bridges, the railroad bridges, and they're wooden bridges, and we can easily destroy them, few men and the horse guards, and the Union troops then cannot come through Baltimore. Okay. Merriman and others believe they have the governor's assent. The governor's account is that, and it ranges these various accounts. Either he was still sleeping, gave no assent, or maybe there was some kind of gesture that seemed like a yes. but on this very limited authority, and perhaps the mayor's authority, who controls the city guard, but these bridges are outside of Baltimore. They go out to the country. Merriman is, not very concealing. There's talks on Baltimore sidewalks where people have said he's trying to recruit people. When he gets there to the bridges, there are locals who do not want him to do this. This is their local economy we're talking about here. This is a local bridge. So he's definitely spotted. And people know that he's one of them doing it. Sets fires to the bridge and the like. This forces the U.S. Army was probably going to start going through York, Pennsylvania anyway, and getting to D.C. through that route and avoid Baltimore. But this forced the issue, and this is why the Pennsylvania troops arrest him. Now, by the way, Merriman's a hero in Maryland. People are bringing him furniture into his cell. He doesn't have to worry about eating prisoners' rations. He's got home-cooked meals brought to him. Later, after the Civil War, he's going to be elected the treasurer of Maryland. So there's no doubt where public opinion is on this side of the question. Taney is livid over what has occurred here. He writes, Merriman's not a member of the military forces. Civil courts in Maryland are open. The ordinary judicial process, rather than military authority, had jurisdiction in the matter. Taney supposed it to be one of these points of constitutional law upon which there was no difference in opinion, that the privilege of the writ could not be suspended, except by an act of Congress, which Lincoln does not have. Lincoln responds to Congress, and he maintains that, yes, the Constitution's silent on whether suspension of the writ of habeas corpus is a presidential or congressional power. The war power and the president's constitutional role as commander-in-chief placed upon him the responsibility to defend the nation against its imminent destruction. Lincoln argues, if Justice Taney's interpretation of the Constitution would allow all the laws but one to go unexecuted, the government itself go to peace, lest that one be violated. You get it? So in other words, if I follow Taney here, I'll be following one law, sure. I'll be constitutional on the use of habeas corpus, but I'm going to permit a rebellion in my own backyard that could stop the enforcement of any laws thereafter, because this government could cease to exist and could be occupied by a hostile power or a rebellious group. Taney is kind of in a pickle here. He's stymied politically. He's aware that he's known to be somewhat shaky on this whole secession question. Personally, he's encouraged people who were leaving the District of Columbia to join the Confederate Army, at least making no effort to stop it. That's known privately among people. His views are kind of known. He's somewhat sympathetic. He's not a fan of Lincoln nor the Republicans. He simply says he knows that the court-martial will be resisted in the discharge of his duty by a force notoriously superior to Taney's own. And such being the case, the court has no power under the law. All I can do is reduce to writing the reasons under which I have acted and report them to the President in the hope that he would perform his constitutional duty to enforce the laws. In other words, to enforce the process of this court. Public opinion generally with Lincoln, of course there's going to be Democratic papers that are going to be against it, but that's not universal. We're not talking about like 1864 where Democratic papers would be against him all the time. Even the New York World Democratic paper is going to generally agree with Taney's decision is not taking into account the situation that's going on that Lincoln's facing. And so there's general support for him. And one of the key distinctions that makes Lincoln's decision to ignore, in effect, the Supreme Court, it's an odd case because it's actually Taney operating under his circuit order. So it's actually the President of the United States resisting the Chief Justice of the United States in this case, to be technical. Lincoln doesn't issue any bellicose statement like, "Ha, take that, Taney," or something, or why don't you try and enforce it? which is a misquote of Andrew Jackson we'll talk about in a bit. But he does say, he does give his legal justifications, and over the course of the war, he'll issue more writs of, more suspension of writ of habeas corpus, including some very general ones that might apply to the entire United States if there's a person who's being disloyal, because the entire Civil War, you have problems behind Union lines. There's another thing, though, that makes this case a little different, and that is that eventually Lincoln does go to Congress, and Congress passes an act that essentially says the actions that Lincoln had to take during this time that we were in recess, we approve. And it includes the suspension of habeas corpus. So it is not long that Lincoln is quote, a dictator. Okay, so that's one of the most serious cases, Merryman, and there'll be others where courts are requiring him to, there's another one, Ex parte Mulligan, where he's, if courts are operating, you have to use those courts. You can't use military courts if it's in Illinois. You got to use, if it's in Arkansas or Kentucky or Tennessee, and there's Confederate troops ahead of you, the military can try cases. But where civil courts are operating, you have to use them. So you have this kind of, maybe without splash, there's Lincoln very much ignoring court decisions. That's one famous example. The other famous example, Andrew Jackson and the Cherokee removal cases, in which allegedly he's to have said John Marshall wrote his decision blocking the removal. Now let him enforce it. And Andrew Jackson probably said nothing of the kind, but he simply did not comply with the court's order. There again, you have a congressional act. It was a close vote. I talked about that in Ashamed of the Day in Judgment episode. It was a close vote. But you do have an act of Congress supporting that removal action. And Jackson would have cited a quasi-emergency in that, I think it's a point that it depends how far you want to take this. If you're like a Robert Remeni, he defends Jackson, that Jackson may have saved Cherokee people from being annihilated, and at least are able to keep the tribe over in Oklahoma. I mean, others note that Trail of Tears and how badly the operation was conducted and how many people died, and it was still a forced move from the Cherokee Nation that only one group of individuals in that tribe wanted to do. But there is the case to be made that state of Georgia was looking to seize these lands, and there would have been bloodshed and could have been many more deaths. They're not great examples of history. They're emergency situations. They're negative situations. The most of history, executive power is checked by the courts, and state power in some cases as well. I want to talk very quickly about Brown 2, because if you take, for example, one could say that this happens with Brown versus the Board of Ed, which is a case in 1954, but there is a second case, Brown 2. Brown 2 is the way that it's known in Supreme Court history books. It's really an extension of the 1954 case, because the plaintiffs, the NAACP being the principal ones, go back to the Supreme Court a year later after their historic decision, which ruled that segregation in American schools was illegal. They say, look, school systems are simply not complying fast enough. And the way to sum up how the court rules in Brown 2 is simply that, yes, guys, you actually have to listen to the Supreme Court. We issued a ruling in 1954. You're essentially not listening, so we're issuing a new ruling. And in fact, Chief Justice Earl Warren is a lot nicer than that in the decision, considering the historic implications that this whole case has. These cases were decided May 17, 1954, declaring the fundamental principle that racial discrimination in public education is unconstitutional. All provisions of federal, state, or local law requiring or permitting such discrimination must yield to this principle. And furthermore, we will take steps. The famous phrase that comes from Brown 2 is that all deliberate speed, because they say that school districts in the South must comply with the court's 1954 order with all deliberate speed. That doesn't mean instantly. It doesn't mean immediately. That's what the NAACP would have wanted in Brown 2. They didn't get, by the way, everything that they wanted. Certainly. They wanted the court to be much stronger. But the court still is strong, and far from that image of the powerless John Marshall falling at the feet of Andrew Jackson with him saying, "Where's your army, fool?" That kind of image is not really where the Supreme Court has been in history. It's the ultimate law. If it doesn't act, it's because its rulings are being complied with. It can act when it's not. Brown 2 is an example. So anyway, all deliberate speed is an order. It may not have been as fast as people wanted, but it is an order. And how I interpret all deliberate speed means without any encumbrances that you're introducing. You have to do things as fast as you can in your school system where you are without you introducing. In fact, he gets into it a bit, Warren, in his decision. Courts of equity may properly take into account the public interest in the elimination of such obstacles in a systemic and effective manner. That is, real obstacles to integrating the school systems. But it should go without saying that the vitality of these constitutional principles cannot be allowed to yield simply because of disagreement with them. The courts will require that the defendants make a prompt and reasonable start towards full compliance with our May 1954 ruling. Once the start has been made, the courts may find that additional time is necessary to carry out the ruling in an effective manner. Okay, so one thing I want to make clear with Brown 2 is that the court has delegated to local courts, local federal courts, I should say, district courts, in their area to monitor compliance of school systems and to take what measures needed to enforce. They will consider the adequacy of any plans the defendants may propose. During the period of transition, the courts will retain jurisdiction. So, for example, just based on the Supreme Court ruling, Prince Edward County, Virginia, by 1959, a federal appeals court is going to just simply order the county to start desegregating schools now. Like, you have delayed enough. We don't want to hear any more arguments. We don't want to hear more objections. Integrate now. And what, unfortunately, Prince Edward County does is just close its school system. And the court will eventually force them to open it back up. That'll take a little more time. Normally, you don't have to set up procedures like this, but courts can. There are all sorts of instances where they can set up a special attorney, a special master to handle legal obligations. Courts, despite some of the rhetoric you're hearing today, are not to be trifled with. And, again, we can go back to that Andrew Jackson quote, which he didn't even say, that a court has no army. And that's absolutely true. But in effect, they do, because they can do everything short of an army. They can create special watchers, special masters, order agencies to do things. And you certainly had in the 60s an example of courts having to create special procedures, ordering around school districts, monitoring school districts, making sure they complied with federal courts because local courts weren't of assistance, and local politics wouldn't create the atmosphere needed to integrate schools. So you had from the late 60s to the early 80s a lot of action on the part of the courts, and it affects the 68 election, the 72 election, 76 election, even some Senate races in 78, including that of Joe Biden. His re-election in Delaware is turning on this busing issue. So it's an issue. And you get a pushback against aggressive federal courts, and that's certainly seen in politics. It brings up a question of how much can you tolerate things that have a function that are like an executive branch, like an enforcement mechanism, but they're not under the direct control of the president. And so we'll talk about a couple of cases there, and we'll talk about Morrison versus Olson, the unitary executive, and Scalia's dissent. But first, I think we want to talk about Humphrey's Exeter case. And that's going to be real important in certain things that are going on even today, especially with a president, say, replacing or firing large amounts of federal employees. So Humphrey's Exeter deals with William E. Humphrey. And it's a kind of funny story if you've ever seen that one Seinfeld episode where George Costanza, doesn't know if he's hired or not for the job, so he just keeps showing up to work each day, perhaps without a paycheck. William E. Humphrey is appointed by President Hoover to be on the Federal Trade Commission. But he doesn't like Franklin Roosevelt. Well, let's just say he doesn't like New Deal policy. Roosevelt is annoyed with him and eventually dismisses him on July 25th, 1933. He said that he was inadequately supporting the policy of the president. But the Federal Trade Commission is indeed that. It's a commission with specific job that Congress would like it to do. It's not a creature of the executive branch. It is part of the executive branch, well, everything is, but it's not a creature of the executive branch. It was created by Congress, who intended it to have a very specific purpose that actually might be contradicted by a president just dismissing the person. So this is the issue at heart. And Humphrey takes it so seriously that he continues to go to work, doesn't acknowledge that he's been fired, and then, of course, he's suing for his back pay. And the reason that it's called Humphrey's Exeter is that it kind of joins the list of cool Supreme Court case names, is that unfortunately he passes away in 1934, but his estate continues to sue the United States government for that back pay. Okay? And we still don't know at the time of his death what the constitutionality is of Franklin Roosevelt simply dismissing this officer. But this is what the court decides. When Congress provides for the appointment of officers whose functions, like those of the Federal Trade Commissioners, are of legislative and judicial quality rather than executive quality, and when they limit the grounds on which they may be removed from office, the president has no constitutional power to remove them for reasons other than those so specified. And this goes directly to another case in the 1920s called Myers versus the United States, in which Taft, then the Chief Justice of the United States, but a former president, said that the president can fire an employee. But the Myers case, the court in Humphrey's Exeter says, dealt with the removal of a postmaster, an executive officer, restricted to the executive functions and charged with no duty at all related to either the legislative or the judicial power. The actual decision in the Myers case finds support in the theory that such an officer is merely one of the units in the executive department, and hence, inherently, subject to the exclusive and illimitable power of removal by the chief executive, whose subordinate he is. The Federal Trade Commission, by contrast, is an administrative body created by Congress to carry into effect legislative policies embodied in the statute, in accordance with the legislative standard therein prescribed, and to perform other specified duties as a legislative or judicial aid. The authority of Congress in creating quasi-legislative or quasi-judicial agencies to require them to act in discharge of their duties, independent of the president's control, cannot well be doubted. And that authority includes, as an appropriate incident, the power to fix the period during which they shall be continued in office, and to forbid their removal except for cause in the meantime. So Humphrey's Exeter is a limit on the president's ability to just fire any employee, including commissioners, because commissioners, and not all commissioners, which has been tested in a recent case, just calling a person a commissioner isn't enough. but where the court reckons that there's a quasi-legislative or judicial function, still remains the law of the land. There has been a recent case involving the Consumer Protection Board that was created during the Obama administration, and when they went after a law firm for some mischievous practices involving collection of debt, the law firm decided to challenge them by challenging the constitutionality of the entire agency. And the court sort of smacked down the law firm and said, no, you're still going to get punished. But you're right. There is an unconstitutional element here, and that is that the head of the commission is fireable by the executive. So Humphrey's executor is being narrowed, but it's not overturned. And there is a situation involving a member of the National Labor Relations Board where there is an open lawsuit and that person is seeking their relief under Humphrey's executor. So the pushback on this limit to a president's power comes in the case of Morrison versus Olson in 1988. And in 1988, there were congressional investigations into the alleged abuse of power by officials in the Reagan administration, really EPA, about how well they were enforcing Superfund. Congress is Democratic, Reagan's Republican administration. Congress demands documents from the EPA. The documents aren't handed over. Now Congress is looking into obstruction of justice. This leads them to Theodore Olson. He's Attorney General at the time. He's Assistant Attorney General. Now, they suspect that he gave misleading information to Congress about these documents, but they need to investigate it. So the Special Division of the U.S. Court of Appeals appoints an independent counsel, Alexia Morrison, under a new law, post-Watergate law, meant to provide a check on executive branch misconduct. This law allows for independent counsels who couldn't be fired by the president because they want to avoid what happened with Nixon in the Saturday Night Massacre, where he fires Archibald Cox, the prosecutor investigating him. Ted Olson, recently passed away, challenged this appointment, arguing it violated the Constitution's separation of powers. He said, this counsel, who's summoning before a grand jury, that's something that the executive branch, Department of Justice, does. The place I work, we do that, thank you very much, not Congress. What power does she have? So that's the situation. However, the way the court rules, in a 7-1 decision, Anthony Kennedy had just been appointed, doesn't participate, and Antonin Scalia, dissents. The other 7 justices rule that it's within the bounds of the legislative branch. It's designed specifically as a check. So yes, while a special counsel might normally be something in the executive branch's purview, we're going to allow this. And I'll read a bit from the dissent because it's this odd case where the dissent is more famous than the decision. I don't agree that makes the dissent better than the decision. I think the dissent has some flaws, but the dissent has become famous because it was prescient. Scalia saw that there was something wrong with this independent counsel law and what it could wreck political careers and things like that. I'll read from that a bit. Doesn't necessarily mean he was right, but one of the main points he's going to make is that you can't argue that something is a little violation of separation of powers. Just a teeny bit. It either is or it isn't. Once you do, you're entering into a kind of never-never land of law where we're making our own kind of eyeball determinations of whether something's a violation or not. So we'll reel it in later, and that'll be just as ambiguous as when we allowed it in this case. You're just destroying the whole foundation for any kind of separation of branches, is what Scalia argues. In Federalist Society, conservative circles, his decision is heralded. There's actually, especially around the time of the Kenneth Starr case, there were many liberals who like this decision, at least in its effect on the special counsel case. Unanswered. And I'm going to read a bit from his dissent in Morrison v. Olson, but I want to just state that unanswered in all of this is the biggest question that's facing us now, as we have a president who's doing it a lot with kind of hundreds, maybe even thousands of executive orders, trying to do as much without really going before Congress and getting legislation necessarily. We know from Myers v. the United States that a president can fire federal employee. We probably knew it before that case because the executive power is vested in a president of the United States. It can't be vested in two people. It would be awfully confusing. And this was a real situation in the early republic as they were trying to figure out things. It would be very confusing to have a Treasury Secretary told to say, go print more money by Congress, and fear he'd lose his job if he could get fired by then, and then told, go print more money by the president if he could fear losing his job, and then maybe have a judge as well ordering him, and maybe that judge could fire him if we didn't have any of these separations. So the decisions made in vesting an executive power, a day-to-day authority, the power to execute the laws. But they have to be laws. There has to be lawful execution. That's a key, okay? That makes everything complicated. And there's reams of legal books about, executive power. We'll talk a bit more. But here's where it gets more complicated. If the amount of orders that you're making, if the amount of executive authority that you're throwing around is such that you're starting to encroach on laws that were passed by Congress, things that Congress wanted. And I think the obvious example is, say, destroying a whole department of the federal government. That's no different than the president, it could be argued, making a law without making a law. He has no power to do so. He only has power to participate in the veto process. That's a very limited power in making law. Laws come from Congress. They also come from previous Congresses, if they're not changed, if the statute still exists. So the president is a creature of law, just like everything in the federal government. And his executive power, though it sounds really cool, and listen, in the most powerful country in the world, having executive authority is a pretty powerful thing, right? And still, it's limited within the restraints of law. And so, again, we have all of these decisions, and I'm about to read a dissent from Scalia on, can you fire employees? Can you fire an officer, say? Because if the president can't, the officers are running the show. And it's been largely done, I think, that as part of day-to-day powers, a president can fire an officer of the federal government. There are exceptions. Molson v. Olson is the exception. Those bodies that exhibit quasi-legislative or judicial powers, where removing the individual would be in effect changing law. And that's been weakened over time, but still is on the books. But for the rest of it, you can fire officers. Congress can't. Judges really can't. Judges can punish. Judges can demand things of officers within the bounds of law, and only for the reason that something's unconstitutional that they're doing or against law that they're doing. They can't I don't think there's circumstance where a judge can fire a person. They just would demand the executive department do it. So it's always the executive department doing things, the judges ordering things, and then all the rules set up by the Congress, if we get this right. But again, what if you fired so many employees that you're just simply negating laws? And that's the question at hand. Anton Scalia died in 2016. He did have a few more cases in unitary executive related cases, and we can always assume him to be a supporter of that. But there's no way we can read into this as what would happen with a larger group of employees than one officer, one person. But I actually want to read his dissent because I think people attribute more to it than what might be here. You have to remember, this dissent is made when arguably there was something that you really could legitimately say was a challenge to executive authority, which is a day-to-day. I do things day-to-day based on the laws that you pass, and I follow the court decisions that you interpret. That's executive. He saw a monster being created. I don't know that it's an acceptance or what he would say about a day-to-day assertion that the executive has all the power. In fact, here's how he starts. It is the proud boast of our democracy that we have a government of laws and not of men. Many Americans are familiar with that phrase. Not many know where it's derived from. It comes from the first, Article 30 of the Massachusetts Constitution of 1780, which reads in full as follows. In the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judicial shall never exercise the legislative and executive powers, or either of them. To the end, it may be a government of laws, and not of men. The framers of the federal Constitution similarly viewed the principle of separation of powers as the absolutely central guarantee of a just government. In number 47 of the Federalist, Madison wrote, "No political truth is certainly of greater intrinsic value, or is stamped with the authority of more enlightened patrons of liberty. Without a secure structure of separated powers, our Bill of Rights would be worthless, as are the Bill of Rights of many nations in the world that have developed or even improved upon the mere words of ours." Scalia then goes over where each branch gets its authority in the Constitution to make it clear. Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may, from time to time, ordain and establish. Article 2, Section 1, Clause 1, provides, the executive power shall be vested in a President of the United States of America. But just as the mere words of a Bill of Rights are not self-effectuating, Scalia writes, the framers recognized the insufficiency of a mere parchment delineation of the boundaries. The greater security, wrote Madison, against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. The provision for this defense must, in this, as in all other cases, be made commensurate to the danger of attack. Madison continued, but it's not possible to give each department an equal power of self-defense. In Republican government, the legislative authority necessarily predominates. The remedy for the inconveniency is to divide the legislature into two different branches, and to render them by different modes of election and different principles of action as little connected with each other as the nature of their common functions and their common dependence on the society will admit. As the weight of the legislative authority requires that it should be thus divided, the weakness of the executive may require, on the other hand, that it should be fortified. The major fortification provided, of course, was the veto power. That's what Madison's talking about. Before we go, whoa, Madison just said president can do whatever he wants. That's not what Scalia's arguing. But in addition to providing fortification, the founders conspicuously and very consciously declined to sap the executive strength in the same way they have weakened the legislature by dividing the executive power. And they were proposed to do so. This is what this lawsuit is all about. And he's talking about this special prosecutor lawsuit. The allocation of power among Congress, the President, and the courts in such a fashion as to preserve the equilibrium of the Constitution sought to establish, so the gradual concentration of the several powers in the same department can effectively be resisted. Frequently an issue of this sort will come before the court, clad, so to speak, in sheep's clothing. The potential of the asserted principle to effect important change in the equilibrium of power is not immediately evident, and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf. Look, you can read his dissent. Here's what he says. The executive power shall be vested in the President of the United States. As I described at the outset of this opinion, this does not mean some of the executive power, but all of the executive power. It seems to me, therefore, that the decision of the Court of Appeals invalidating the present statute must be upheld on a fundamental separation of powers principles if the following two questions are answered affirmatively. Is the conduct of criminal prosecution and the investigation of whether to decide to prosecute or not the exercise of purely executive power? Second, does the statute deprive the President of the United States of exclusive control over the exercise of that power? Surprising to say, the court in this decision appears to concede an affirmative yes answer to both questions, but seeks to avoid the inevitable conclusion that since the statute vests purely executive power in a person who is not the president, it is void. Remember, as I'm reading this, Scalia did not win this case. Morrison v. Olson is still law. He's the only dissenter. It's just become a famous dissent, and a lot of people liked it after Kenneth Starr. Let's put it that way. But I want to point out what he's opposing here. Okay. The president was being forced to appoint, really the attorney general was being forced to appoint an independent counsel. They could change who the counsel was. They may even be able to fire at great political peril this counsel. But they're being forced to appoint it. It's not their choice. As he says, it affects a revolution in our constitutional jurisprudence for the court, once it has determined that purely executive functions are at issue here, and those functions have been given to a person whose actions are not fully within the supervision and control of the president. Nonetheless, to proceed further, to sit in judgment of whether the presidents need to control the exercise of the independent counsel's discretion is central to the functioning of the executive branch. It's conceivable that if Congress passed a statute depriving itself of less than full and entire control over some insignificant area of legislation, we'd inquire whether the matter was so central to the functioning of the legislative branch as to really require complete control, or whether the statute gives Congress sufficient control over the surrogate legislator to ensure that Congress is able to perform its constitutionally assigned duties. Of course, we would have none of that. Once we determined that a purely legislative power was at issue, we would require it to be exercised wholly and entirely by Congress. Or to bring the point closer to home, consider a statute giving non-Article III judges just a tiny bit of purely judicial power in a relatively insignificant field. Is there any doubt that we would not pause to inquire whether the matter was so central to the function of the judicial branch as to require complete control? So, I'm summarizing a lot of what he says. He says, look, we wouldn't tolerate it if it was the other way around. If the president said, for instance, I'm a judge, and he doesn't say it that way. The form he says is, if the president said one of my administrative judges can handle a civil or criminal court case now, we wouldn't accept that. It has to be a separate judicial branch. And we wouldn't tolerate if the president usurped one of Congress's powers. And he doesn't specify what that is, but I can imagine it's like passing a law. You must consider and debate on this law now because I said so. All you got is the suggestion of items for Congress's consideration, and he can call them into session. He also gets into, well, what about if it's an investigator to examine a crime that the president may have committed? And he argues, well, it's no different than if Congress passes a law that they're exempt to. There's always conflicts of interest within these branches. So, look, I mean, we're still talking about something that's a single dissent. I tell you, though, he looks a real prophet when you see things like this. Nothing is so politically effective as the ability to charge that one's opponent and his associates are not merely wrong at it, naive, ineffective, but in all probability crooks. And nothing so effectively gives an appearance of validity to such charges as a Justice Department investigation, and even better, prosecution. The present statute provides ample means for that sort of attack, assuring that massive and lengthy investigations will occur, not merely when the Justice Department, in the application of its usual standards, believe they are called for, but whenever it cannot be said that there are no reasonable grounds to believe they are called for. The statute's highly visible procedures assure that, unlike most investigations, these will be widely known and prominently displayed. Thus, in the 10 years since the institution of the Independent Counsel was established by law, there have been 9 highly publicized investigations, a source of constant political damage to 2 administrations. There's a third coming when he writes this, for general legal activities. On this podcast, look, I mean, I'm not here to argue court cases per se. I'm just looking at what's already been decided. There's better podcasts. You got SCOTUS blogs, and you got Strict Scrutiny's one that I listen to. You know, they're going to tell you about the court cases and get into detail on the law. For me, though, I'm just interested in the history and how things have changed, as I always do. And this, like so many points, is just one where things have changed, where now, you know, federal judges at the district level should have no power. You know, in a recent decision about, you know, paying invoices, Alito dissents and says that a single lone district judge should not be able to stop the executive branch. And it's this from The Guardian. J.D. Vance, the U.S. Vice President, has been accused of threatening the U.S. Constitution after telling judges who have issued rulings temporarily blocking some of Donald Trump's most contentious executive orders that they aren't allowed to control the president's legitimate power. Vance's intervention came after Judge Paul Engelmeyer, a U.S. District Court judge, issued an injunction stopping Elon Musk's Department of Government Efficiency from accessing Treasury Department central payment systems in search of supposed corruption and waste. Engelmeyer's ruling triggered an angry riposte from Vance, a graduate of Yale Law School, who claimed judges had no legal right to restrain the president's agenda, and compared it to telling a military commander how to act on the battlefield. If a judge tried to tell a general how to conduct a military operation, that would be illegal. If a judge tried to command the attorney general in how to use her discretion as a prosecutor, that's also illegal. Judges aren't allowed to control the executive's legitimate power. In fact, The Guardian says Article 3 of the Constitution confers a power known as judicial review, which gives federal judges the authority to rule on cases involving the president as well as other branches of government. As stated, it's simply wrong. As a matter of politics, as a matter of some type of brevity of a statement that he meant to include a bunch of exceptions and caveats and things like this, or felt that in this case it was overstepping, but certainly in other cases, sure, the statement can stand. But in the way that it's stated there, what Vance says is just demonstrably false. A judge can very much order a president to do something. We started this episode with a judge ordering a president to hand back steel mills that he had seized from companies. And he had a very good, in his mind, reason for doing it. He had even a perhaps pretended reluctance to do it. And nonetheless, the judge ordered him to hand it back. And of course he did. I mean, if it's even necessary, Because I've seen things where people have argued, like, there's nothing that a district judge can't tell a president what to do. Well, you start with the district judge, then you go to appeals, then you go to the Supreme Court. So that's just a process. But absolutely, it could stop there if the appeals court upholds and if the Supreme Court decides not to decide on it. They decide not to hear it. Certainly a district court can tell the president what to do, can tell a general what to do. They'd probably speak to the general through the president. So it's a technicality, but they can absolutely order a general what to do, tell a general what to do. Some of these people are forgetting either Biden v. Nebraska, where several states, including Texas and other states, went to a district judge and asked them to stop a president from implementing the student loan program. Eventually, that was blocked. Or the 2016 case, United States versus Texas, where a bunch of states, again including Texas, went to the court to stop a president's plan. In this case, President Obama's plan to expand the Dreamers, the DACA immigrants program, to their parents and create a DAPA program. So if there is a rhetoric out there that, district courts can't tell presidents what to do, it is something that, Biden v. Nebraska was 2023, so it's something that's awfully new. And in my view, doesn't really stand up to look at history. I hope you've enjoyed this look at presidents and judges, because it's come up, as is the case with everything going on today. Things are happening faster than I can get to them, but don't you worry. I've got my history books open, and we'll get to things at least eventually. I know there's already now a big talk about leaking military plans, and that's the new issue, but I got to go with, I got to take some of my time and make sure we look at things, compare and contrast, and argue them well. If you can join the Patreon, you'll get even more. Please consider that, and I do thank you for listening.